Welcome, everyone, to the Bold Today Show. I'm your host, JD Houvener, and the owner and managing partner here at Bold Patents Law Firm. You've come to the right place if you've got questions about patent law, intellectual property. We welcome all those live questions. This is the place for you to bring, anonymous questions that are not confidential. And so as I start my show, normally I will offer a disclaimer. We are a law firm. I'm a patent attorney, but I will not be giving legal advice in this live session. So if you're looking for legal counsel, I encourage you to visit our website and schedule a screening session. I'll provide a link today for you to do that. So please don't share confidential invention information in this session, but I'm more than welcome. Any questions about the process, how to get started, and today we're going to be featuring, I've got two guests for you about patent searching, right? What does it mean? How should you do it if you're going to try to do it on your own? How do professionals do it? What are some things to think about? So as we go along our show, we'll be featuring that and bringing those guests on shortly. Then we'll break to our normal segment where we'll answer Alvo.com questions. So if you're an Alvo.com listener watching live or after the fact, I will be jumping to that at about the 10 or 12 minute mark. So you're welcome to fast forward to that. But I encourage you to please hang in and watch. I think this will be informative for you. All right, so without further ado, I want to welcome our guests. We have two patent searchers. These are professionals in the patent search industry, and it's an honor to have them here on our show. We've got Glenn Kotopish of Planet Patent and Brandon Kinney of Aegis Patents. So we'll bring them on the show, and we'll welcome them to the program. So welcome, gentlemen.
Morning.
Oh, JD.
All right. Well, thanks for being on. This is fun. This is the first time I've had more than one guest, so hopefully the people are able to kind of see the different faces here. And I said we've got one live viewer for now, so hey, at least we got someone out there. For those of you that may be watching live or after the fact, we're always looking to increase our viewership. So please give us a like, share this with your community on social. This is hopefully will be a growing community where we do a weekly live session, and we're here every week, every Wednesday at 9 a.m. So again, this week, thank you for that like, by the way, it's awesome. And ask those questions, okay, as we get started. So I've got two questions for you, gentlemen. I'll kind of just let you spitball and answer to kind of warm things up. The first one is if you're a first-time inventor or you're going through this process. Hey, Janelle, welcome to the show. What is the most surprising thing that inventors and business owners that have inventions realize after they sort of work with you and get a report on their invention? And Brandon, I'll let you go if you don't mind going first.
Sure thing, JD. Often I guess if you're working on your own as an inventor, doing some preliminary searching, I mean, sometimes it's very difficult to find to determine that your invention is going to be patentable. Sometimes you can find something fairly quickly through keyword searching that's going to tell you, oh my gosh, this is exactly like my idea. Then sometimes in those cases, you may do a quick consult with someone like JD, and he can say, yes, that actually is just like your idea, or maybe there's some ways we can work around it. But between that, and I think one of the other things is that, as you will probably see pretty quickly, looking through some patents, is unless you're used to reading them every day, they're pretty difficult to understand. And
right.
What's often and another thing is that the key about doing patent searching is identifying particular teachings within a patent. So whatever the title says, the apps it doesn't that helps you find the right patents. But it often could be that little needle in a haystack that's just one sentence buried in a 25-page patent that teaches the core inventive concept of your idea, and then it's problematic. And part of the, another thing that you often don't know is that it's, aside from just saying yes or no with patentability, is that, a good patent search will help you understand what the scope of patentability is for your invention, where, depending on your goals as an inventor, you may realize, yes, I can patent this, but that patent is also ultimately going to provide me very little protection. So it depends what your goal will be. Some people want to build a whole business around one patent, in which case you'll need a strong patent. Whereas in other instances, you're trying to build a portfolio of IP, or use, a lot of inventors use this for fundraising and marketing, or to be patent pending.
Right.
about the best thing you could have in a 30-second elevator pitch. Yes, the product is patent pending. It's one of the first questions they ask on Shark Tank. So,
Yeah. Right. Exactly.
often, depending on your business and market, there's simply value in that. But I'll let Glenn build on that a little bit.
So,
Yeah, Glenn.
so the things that surprise inventors was the question, right?
Yeah, exactly. I mean, from your perspective, I mean,
Sure.
what are they? What's the first thing they're like, oh wow, about when they see a report, when they kind of get into the process working with you
Right.
and doing patent searching?
Well, sometimes the surprise is, can either be, wow, there's a ton of stuff, and that's not necessarily bad news, or maybe there isn't a lot. I mean, if it is unique, if it is innovative, then that's a good surprise. I used to joke, I get paid to disappoint people, but it's not really. That's not it, because even if you find things that are similar, that information is valuable, and often people are doing a lot to solve the same problem in a lot of different ways. So that can be encouraging if there is room for innovation.
Yeah.
The other surprise might be, well, hey, I haven't seen this product on the market, so I'm sure it hasn't been patented. Well, there's a lot of patents sitting there on the shelf that didn't make it to market, or they were and didn't make it, or whatever. So that's one of the other surprises too. It's like, hey, somebody did this and they didn't go anywhere with it.
Right. Yeah. So I'm kind of hearing two things, kind of big takeaways, and this also resonates from what I hear from our clients is that one, and you mentioned this, Brandon, where people see, they might even go before they hire a law firm like ours or hire a search agency like yours. They see, the big cover page or the abstract, the picture on a patent, or they Google something and they must have rights on that. I'm not going to be able to go after it. And it's only maybe discussed quite generally. And it is about spending the time, either hiring a professional like you or our firm to read through and see if it was actually taught, right? See if it actually was thoroughly discussed. And there may be more room for potentially, for locking down rights in a certain area. And then, that the idea that you don't need to have, that you shouldn't just skip the search, right? And so underlying the importance of knowing as much as you can about the priority, the current state of the art before filing a patent application is so important. And that's why I've gone through a lot of patent search firms, and that's why I like your guys' firms and the way you guys do searches, is because you're quite thorough. And I feel like as a law firm, that's one way that we can we definitely differentiate ourselves from the likes of like a patent promotion company or something like that, where it's instead of just feeding the entrepreneurial desires and want to just go big without actually doing a little diligence first and getting that solid legal opinion that we are able to form from getting the information and data and results that you guys put out. I'm so proud to go to that. So thank you for answering that. And of course, we're going to take the live questions. I have one more question for you guys. I know it's sort of related to the prior question, but in terms of what you see either through working through a law firm like ours or through working directly with entrepreneurs and inventors, what's the most important thing? Like this, pick one thing for them to take away about patent searching, right? What in terms of what they get from a patent search? What would you say is the most important thing for them to understand?
My feed was breaking up, but if you want to go first, Brandon, go ahead. I can catch on.
That's a tricky question. I think the most important thing for an inventor to understand is that, one is that they're kind of infallible to an extent. Is that it is possible. You sometimes you see me miss things, but that's pretty rare. And I think ultimately you should look at it as a tool to help build your business and your invention. And as you look at how you're going to protect it, you say, like build on what JD said is, what is the field of prior art, and what aspects of my invention will I be able to protect? And you can invest your time and resources wisely to build those competitive barriers for your business.
Yep. Awesome. And I would just say, are there ways that entrepreneurs or inventors can, and I've sort of seen this in a lot of cases where they'll see the report and say, you know what, darn it, it looks like my invention, a lot of this has already been, part of the prior art, and I need to go back to the drawing board, right? And they can use the information gained to know where there seems to be gaps, right? Where they can actually use a search for a solid search report to go back to the drawing board and design around, make improvements that there seem to be, major gaps in terms of the technology and functionality. Have you seen a lot of that? Where there's basically folks that'll come back from your opinion and sort of come back at it and try to redesign.
I think it's important to have that initial look, and look at patents, look at non-patent things, have that initial look. I tell inventors, your invention best, but you need to see the context of what's patented and what's on the market that may not be patented, so you can kind of see where it fits. And it's valuable to see what people have done and are doing in the patent space too. What are they bothering patenting? Maybe they're not patenting something, or maybe they're doing design patents primarily in a certain area. So it's a lot of valuable information up front, and then they can, retool, come back, and maybe do a follow-up search on their new idea. Yeah.
It's funny you say that. I think you mentioned that, Glenn. It's your job to kind of give the bad news, right? But and it's freeing information, right? It's really important, and I feel that as a duty, as an attorney, it's wonderful to be able to tell someone the truth that, hey, we didn't think, you're not going to be able to get this in terms of your scope of rights. We think we can get you this, and you can really look them in the eye and tell them the truth and be very clear about, well, okay, we think we can still make a ton of money and make it big in the market with this, so let's do it. And it's so comforting, right? And it's a wonderful way for our firm to be able to walk side by side with our clients and to help them through the process and to have a good, reasonable expectation when we submit that patent application for when the examiners take a look at it. And we hope that we've done our best to put ourselves in the shoes of that examiner in advance. And you guys make that possible. So thank you for that. What I want to do on the next segment here is, before I jump to the AVA, I want to make sure I get you put up on the comments here.
Can I just add one short thing?
Oh, yeah, for sure. Go ahead.
Sometimes when clients, inventors ask about the search, I say, be sure to consult, patent attorney. And then if you're not going to look for a patent protection, consider the infringement possibilities too, as a second step. So, that can be valuable. Maybe they're not going to file a patent, but just make sure you're not stepping on toes. So anyway, that's the other thing too.
Totally. Huge benefit. Yeah. While you're doing a novelty, can I get a patent on this, kind of question, and analysis, what falls out of that are some beneficial tidbits about who are current enforceable rights holders. Right. And not only we don't think you get a patent, but we don't think you should go to market, without, serious risk of potentially stepping on the toes of another rights holder. So
it can also help inventors. Yeah, and I was going to say, that can also help inventors where they may have an idea and they're looking at something at a conceptual stage. You'd see a lot of active grants in that area. And, you can tell them these are the areas, these are the bottlenecks that you need to design around, because if you do it this way, there's potential for problems.
Absolutely.
And the licensing aspect, sure, you might find those players, and then perhaps your small improvement that does sit on other IP is enough to think, hey, I can give this company an advantage, even if I'm not going to do it myself.
Right. Yeah. And totally true. Yeah. I mean, I would say the majority of patents granted today are improvements, right? And so to actually go to market with, for example, the classic analogy I give is you've got a brand new rear view mirror or add-on to a car. Well, you can't go sell the whole car with the new mirror. You're going to have to somehow work with the manufacturers and the companies retailing those kind of cars if your new improvement sits on the car, right, as part of a widget that is already protected. So, yeah, thanks for that, Glenn. We do have a live question that came in from TSDZYF. I'm not going to try to pronounce that. Hi, thank you for organizing the broadcast. I have a question about drafting claims. Why do people always want to give a very broad name to an invention? Okay. Well, there's two different questions in a way, and not necessarily specific to patent searching, but I thank you for the question. Drafting claims is, a patent attorney's, that's their main mission. That's their main focus is to get for their client inventor the broadest rights possible, so that they're able to protect what they're going to be hopefully going to market and selling to get them that reward. And so, the claims themselves need to be, pushing the limits in terms of what they've invented. And so it's words, it's English words, and it's a set of, elements. If it's a structural claim, it's a set of steps. If it's a method claim. Now, in terms of the title, which I think is what you're asking about with a broad name. Yeah, for example, if you've invented, let's take with that example about a new mirror for a vehicle that's got solar power and it's somehow able to automatically order food for you at a drive-through, whatever, something. Okay, and that's your improvement. That's your invention. You're not going to name it takeout food ordering review mirror system. Okay, that's very specific. We'll try to probably just name it side mirror system, right? Because you want to try to, in your claims, you'd want to try to encompass much more functionality than just ordering takeout with your side mirror. Maybe it could also, speak to someone in traffic if you're stopped. Or who knows? Maybe give the police officer information if you're pulled over. I don't know, all different kinds of things. So you want to keep the definitions, the abstract, and even the title as broad as possible, because you want to explain that you've got more rights than the one perhaps version that you're going to market with initially. So thanks for that question. One more question from Jake. Do I need to get a patent pending in the prototype stage? Well, Jake, that's the $1 million question. It's sort of this very in between phase, right? You've got an idea, trying to get it to the stage of an invention. Okay, and so I tell a lot of inventors that if you're still in that idea phase and you haven't quite been able to, convince yourself that this invention does what you think it's going to do, you're still in that proof of concept, phase. I don't think you're ready to file. I don't even think you're even ready to do an adequate patent search. Work on your own, right, in your lab, in your setting, your garage, on getting it to the point to where you could explain it to someone else that does what you do and how to go build it. That's when you're actually at the point where you've got an invention and you've got enough detail to where a firm like ours and patent searchers like Glenn and Brandon here could do a very valuable search for you. Right? If you've got enough elements and aspects, structure, detail about what it is you've invented, you're going to get a whole lot more out of a patent search as well. So thanks for that question, Jake. All right, gentlemen, I'm going to put you backstage. Hopefully we get some more questions trickling in. I'll bring you back in just about 5 or 10 minutes and we'll wrap up, okay?
Thanks, JD.
Right. Okay, so thanks for waiting for those AVO listeners. I'm going to be able to get to about 3 questions, I think, and I'll share my screen here. You're welcome, Jake. There were like 13, and they were all trademark questions, interestingly enough. I didn't see any patent questions. So those of you who may not know AVO, this is a place where I volunteer as attorney to answer anonymous questions from around the country. And I try to get to as many as I can every week, but sometimes there's a huge volume, and this session is only a half hour long, as you know. And I prioritize those live questions, so hop on live if you've got a really good one. I'll take this first one here. This is out of Fishkill, New York, asked just about 17 hours ago. And I'm reading these live, so some of these questions are way out of the blue, so I apologize in advance if we get that. The question is, are infant bodysuits and T-shirts the same thing in regards to trademark? I recently received a trademark registration, kudos to you, that's awesome, for a specific phrase on infant bodysuits. Can I stop people from selling this phrase on infant T-shirts as well as bodysuits? Well, probably, and I sort of caveat this whole trademark, session with the fact that my training is as a patent attorney. And if you get a tricky question, I'm gonna quickly defer you to speak with our in-house trademark attorney, Matt Colseth. As far as I'm aware, with the trademark classification system, it's possible that there are separate subclasses of goods and services for adult apparel and child or infant apparel. But I would imagine if you've got a trademark registration on, let's call it, little wear, right? For infant clothing, and you've got registration for little wear, and you sell infant bodysuits, okay? And someone else comes along and they're trying to use little wear for adult apparel, adult bodysuits. To me, that would seem to definitely conflict, right? That would be it would rise to the level of their customers, your customers, your actual or potential customers might be confused. Is this little wears? Are they trying to now sell to adults? So just offhand, it certainly sounds like an infringement if you've got a federal registration. Of course, we'll need to take a closer look, but it does depend on the actual classification that you got your registration in. And if that is broad enough, if it's just plain apparel, well, certainly it would cover adult apparel as well as infant apparel. But if it is, for example, if there is a subclass and maybe you only got a registration for children's clothing, it is conceivable that there's a different category where you would not be able to get those rights. So that was a little rambling, but thank you for your question, and it was a sort of intriguing one about trademark classifications. So we have a question here. I'll jump back to our live session. So that 3, this is more of a general question. Are you working together with clients abroad? We do have a few clients. I mean, I'm not going to say we do a lot of this work, but we have maybe 10, total that are, they live overseas, in a non-U.S. jurisdiction, and they're seeking rights here in the U.S. And then we have several clients that are based in the U.S. that are getting rights overseas. So if that helps answer your question, great. But yeah, if you have any more details, you're welcome to follow up, Sven. All right, let's jump back to Avo. Let me share my screen again. All right. Okay, so this one's out of Silver Spring, Maryland. Can I oppose this pending trademark when it publishes for opposition? I'm a visual artist and I sign all my artwork under my pseudonym. I've been using this name for years. Over the years, I've cultivated a unique brand name specifically for my artwork. It's not the name I use to sign my artwork, but it does have my pseudonym in it. Okay, interesting. I've trademarked that specific brand name, but not my actual pseudonym. Okay. This is detail. This may go beyond the scope. I'm not sure. I guess I'd have to sort of see what's going on here. Under a pseudonym, pseudonym, I believe, is so it just means a name that's not your actual given name. I believe that's what that means. And using this name for years. So there's a brand for your artwork. That within that brand name, you've got your pseudonym within it. And you've branded the whole brand name. You've got your registration for what customers know your goods as, but not your actual pseudonym. Okay. So you notice that someone else filed under your pseudonym only, and there are a lot of trademarks that actually use a pseudonym as a standard character mark. And I'm just reading here, folks. Sorry about that. So bottom line, yes, you definitely have the right to oppose a mark that you believe you have prior use of. Absolutely. So in trademark law, you have common law rights in terms of what you're calling your goods or services, how your customers know you as, what the name or logo or design, whatever your customers see that name and they know, oh, that is this company's goods and services, right? That's the intent. And so as soon as you start using that name, you've got some common law rights. At that point of first sale, right, it's called, you've got those rights that start to be, in place and wherever you're doing business. And so if you've been using this pseudonym for this whole time, I think it's arguable that has been a part of the way that customers perceive your goods as a visual artist. And so I think you've got plenty grounds to oppose another's attempt at registering that pseudonym if you are very certain that your use, right, your sale, your use in commerce of that pseudonym precedes their use. So take a close look and see what you've got. There will also be a few other things that come into play with respect to geography, like where you were selling your products, right? If you were only selling as a visual artist in a very local way, say like only in person at a studio in one specific town, then you may only have the rights that predate that in that small region where you were doing business. Whereas this other future potential rights holder, they may be selling online and have customers nationwide, if not worldwide. So there's some of that can come into play. But long story short, give us a ring. I can get you in touch with Matt. And sorry for the long-winded answer, but I feel like it deserved it. So just 2 questions today. I apologize for those awful question askers. I just got to 2. I'm going to stop sharing and bring us back to the live questions. Courtney Trotter had one. Don't know if you remember speaking with me, but I'm a current client with Bold Patents. Currently in the prototype phase in patent pending my product. I have a trademark question for you. If a particular product name is trademarked, can I choose to spell it differently by 1 or 2 letters? And can I trademark that name? Well, possibly. And I'm going to have a get with Matt, Courtney. So if you haven't already been introduced to Matt at the firm, we'll set you up with a free, complimentary 30 minutes with him. And he'll go through that with you. The key question is, would a customer be confused by the changing of the letters? If it sounds alike, if it's close enough, and if it's certainly within the same class, right? If you're selling the same types of goods or services, and you're just changing a few letters, that might be too close, all right? But it may not be, right? Certainly changing a few letters can definitely change the sound and the way that it appears and all of that. So get with Matt on his opinion. Svet had a follow-up. I plan to file the patent in the US. The only thing that I am from Germany. Oh, absolutely. Yeah. It doesn't matter where you live and are. If you're seeking rights in the US, you'll want to work with a good patent attorney, a patent law firm. And why not go big and go bold with Bold Patents? So be happy to work with you, Svet. To that point, I will provide a link to a free screening session. And if you take action today and schedule a session following that link, we'll give you a copy of this book behind me, Bold Ideas, The Inventor's Guide to Patents. It's a wonderful guide. I wrote it myself. It's a nice way to sort of get started, right? Start learning about what the differences are between a provisional and non-provisional, between a trademark and a patent, the basics of trade secret law as well. So I encourage you guys to take action. You're welcome, Svet. All right, well, Brandon and Glenn, I will bring you guys back on. No direct questions for you, but I just wanted to finish up by saying thank you for your time and appreciate you coming on the show.
Thanks, JD.
Appreciate it.
Awesome. All right, well, take care, and we'll have you on maybe later for a deep dive about patent searching at some point too. Have a great day, y'all.
You too.